Good afternoon and hello, GovCon HR friends. Welcome back to the GovCon HR Round-Up podcast. This is actually the 25th edition. Call it our spring edition, although it's like 35 degrees in our studio and it really doesn't feel like spring, but we won't go there. It is nice outside and it's turning into a beautiful spring here in DC, hopefully for the weekend. But welcome back, everyone. Especially welcome to any first-time listeners that are joining us. My name is Joe Young. I am the founder and general manager of GovCon Pay, now a division of iSolved HCM. We are the only outsourced payroll and HR solutions provider focused exclusively on serving the government contracting marketplace. As always, we are joining you live today from the studios of BLC Digital Strategies here in Tysons Corner, Virginia, under the leadership of our producer, Mr. Todd Castleberry. Before we get started, I also always want to thank and recognize our sponsor, our friends from Berkshire Associates. For those of you not familiar with Berkshire, they are HR compliance experts with over 50 years of experience providing compliance services and technology for organizations looking to build their ideal workforce through compliant non-discrimination services. So a special thanks to any Berkshire listeners who are joining us today. Today, for those of you who are loyal listeners, we are down a teammate today.
We are.
He's enjoying some spring break. I think actually some college visits with his daughter.
Yes.
So we hope our good friend Declan is enjoying his travels.
He did say Tiger Woods will be driving, so I'm a little worried about
Okay.
that, hopefully he'll be okay.
Hopefully he'll be okay. Right from the headlines here on the podcast, right on the roundup. But I am here, obviously, with my friend, Mr. Seth Berenzweig, one of the founding partners here from Berenzweig Leonard LLP. For any of our first-time listeners here, Seth, why don't you introduce yourself and the firm briefly?
Thanks, Joe. Hi, I'm Seth Berenzweig. I'm a co-founding and the managing partner of the firm. Our brother-in-arms, Declan, can't be here today. He'll be certainly back for our next broadcast. But I help run the government contracts and transactional space here at the firm, and also handle quite a bit of HR matters for companies in the federal space.
Great. Well,
Yeah.
as a reminder, always, as I shared, we are coming to you live. So if anybody has any questions, we will be monitoring the chat, and we always look to try an opportunity to address as many of those if we can during our time today. So, topic for today, we spend a lot of our time, our last 25 episodes, obviously talking about a lot of compliance issues,
Yep.
how to stay out of trouble, how to put correct policies in with your employees. But as they say, sometimes stuff just happens, right?
Yeah.
And you may end up in a situation where best of planning, best of policies. You've got situations that truly require lawyers. And I think this episode we're going to get more into some of the legal side of things. Specifically today, we're going to talk about litigation versus arbitration. And when you get in these situations where you have to go to court and you have a situation, what are the things that our listeners should be keeping in mind, thinking about from a strategic perspective?
Sure.
And also we'll talk a little about as you're looking and building policies, what are some things you should be writing in and considering
Sure.
to set the table for the best outcome and the best opportunities from a client perspective.
Yeah, absolutely. And let me just say a couple of words just to kind of get us started here today. So first off, this sounds like kind of a dry procedural issue. It's not. It's actually a very substantive issue because where you have to handle your case is going to determine your rights and how that case is going to be handled. So what venue you're in, where you are handling your case is, as we'll discuss, is a really big deal, and it could have a very dramatic impact on the different kind of rights that you may or may not be able to have. In the world of litigation, there are generally two paths that the case can take. In a more arguably traditional path, you would be in court litigation, which is state or federal court. Which is what a lot of people are familiar with. But increasingly, we're also seeing litigation go down a path of arbitration. Arbitration is a mutually agreed venue in which the parties agree that they will not go into a public courthouse, but rather will go into one of the arbitration organizations that provide a venue for the resolution of those kinds of claims. Nationally, the organization that is most readily known is what's known as the AAA, the American Arbitration Association. So when you look at a contract and it says parties agree all disputes will be resolved with the American Arbitration Association, yada, yada, that's an example of how that pops up. There are other more locally based groups that in this DC metro area, understanding that many but not all of our listeners here today are in Washington. They might be, for example, in Huntsville and elsewhere. There's a group called the McCammon Group, which is also a very well-known, reputable organization. But you have those different kinds of venue, and as we'll discuss, where you are is going to say a heck of a lot about what you can and cannot rely upon to protect your legal rights.
No, and I'm glad you gave that little disclaimer at the beginning because I do worry. People they went litigation, arbitration, and you worry about a lot of people like geez, and they signed off. Now we got them hooked in for this important content.
Yeah, and
so that was good.
Yeah, and
we don't want to scare them off with the legal stuff.
No, we don't want to scare them off. But the other element that I would encourage people to also keep in mind of the importance is not only the fact of how monumental it is in terms of what your contract says of where you go, but the fact that you control it. So if you can actually control it, we're going to talk about how you might want to make the decision on how to control it today.
Yeah, we use sports analogies here a lot. Controlling the playing field may be the most important thing at the beginning of the process.
100%.
Right out of the gate. So
absolutely,
that's what we're going to talk about a lot today.
Yep.
Some of those things you need to go in before you're in the situation to create the best playing field for whatever you're dealing with.
Exactly.
So I think generally, a lot of people have arbitration's faster, it's cheaper than litigation. That's why we put that in there.
Yeah.
Truth, fact. What's the reality there?
So the answer is, maybe, maybe not. It depends. I think that it is a little bit of a fallacy to say that you will definitely have a faster, cheaper, cleaner route if you have arbitration. Because, first of all, you still have a lot of the procedural mechanics in arbitration, in the arbitration venue that you would have in a court proceeding. And quite frankly, if you end up with some kind of a dispute about the exchange of information, discovery of documents and so forth, if you're in a court, you can get an answer on that within, say, 10 to 14 days. Whereas if you're stuck in arbitration, it may just be like a cloud just kind of floating around. So the answer is maybe it could be faster and cheaper, but to just make that as a general assumption, I think is a little bit of a general, it's not necessarily correct. And I'll give you, in terms of what is cheaper is also a function of what is more cost effective. One of the biggest differences of arbitration is that other than for extraordinarily rare circumstances, you get no appeal right, nothing. Yeah. So one side is going to end up being moderately to pretty happy with the result, and the other side is going to be moderately to extremely unhappy with the result. There's no right of appeal. So for a party who would go in and say, oh, this is going to be, this is just going to be a piece of cake, it's not going to be more cost effective if you go into a process that, even if it might be a little bit quicker, is just going to drop you off at a dead end. So there's a number of factors to consider.
And from a cost perspective, you go into litigation, a judge is assigned to hear your case. In arbitration, you're paying the arbitrator, you're paying the judge. So you've got costs there that you wouldn't even have in litigation.
That's an excellent point. So in court litigation, in state and federal court, the judges are essentially paid by our tax base. And other than a filing fee at the courthouse door, which is usually, a few $100, you have your judge. The judge is there. The judge doesn't send you a monthly bill. However, in arbitration, you have an arbitrator that the parties ultimately jointly have a role in selecting, and then you get billed every month, and you're paying for that arbitrator every month. And some of these arbitrators, they could charge $700-800 an hour. So again, what is less expensive is really in the eye of the beholder.
And so in litigation, everybody's Everybody watch their courtroom dramas. Everybody's
Yes.
familiar with that process.
Yeah.
Typical meats of those process are interrogation, subpoenas, document requests,
Yes.
depositions. Is discovery the similar type of process available in arbitration?
Generally, yes. It's similar. It's not the same, but it's similar. When you are in a state or federal court litigation, you have a variety of tools in your toolbox to ask written questions, written document production, third-party subpoenas, depositions. In arbitration, some of it is like what I would call discovery light. You have a limited amount, but a certain amount of things that you can ask for. So it's similar, but it again doesn't give you quite the latitude and quite the leverage that you would have if you were going through the entire mechanism of a formal court process.
And my general understanding is, again, a formal court process, judge, a public process,
Right.
arbitration, more of a private process. So, would arbitration make sense, if a company didn't want to dispute things kind of in a public record in a court?
Right.
Is that part of that decision matrix as far as the public-private piece of that?
It's a good question. I think that there are certain instances where, for example, if a company wants to litigate trade secrets, if they feel that they might want to have a more private venue, then you could argue that would be a positive element for arbitration. But the thing to keep in mind is that if you are in a state court, if you're in a state or federal court, you can still have things sealed. You can still have things protected. You can still have things designated as confidential under what's known as a protective order. And the parties, either by mutual agreement and consent, or if the other side's not cooperative, the other side can just file a motion or request with a judge for the entry of a protective order that can protect these things. So for the most part, you can still keep things sealed and protected in a court process without having to worry about being stuck in a room with some random arbitrator with zero protection of appeal rights. So it's interesting because there are some companies that have had a history of wanting to have a presumption of privacy, where they don't want to have their dirty laundry aired. So maybe, for example, I've seen a lot of employment cases where companies, for some reason, like arbitration. And again, it's not that there's something necessarily deeply flawed with that, but the problem is, in this jurisdiction, courts in certain instances are likely to grant what's known as summary judgment, where you don't have to go to a full trial. It depends whether you're in state and federal court. I should also note that although it is true that there are a number of our listeners that are not here in the Washington, D.C. area. So, for example, we have some very good friends and business colleagues in Huntsville. A number of those companies may also have a presence here as well. That would foot with having a venue selection clause here because they're doing business here. But again, even if they're in California, they can make their own independent analysis as to whether which they want to pursue relative to those two options.
Yeah, and I think that was a big thing you touched on earlier. Is location matters.
Absolutely. Yeah.
And I grew up in Delaware, so I always know that Delaware, we don't have a ton of claims to fame.
Yes.
But a longtime claim to fame is Delaware. Is 400 of the Fortune 500 companies are incorporated in the state of Delaware.
Yes.
It was always a big thing. And all of a sudden, the CEO of Disney's in some little Sussex County courtroom because they're a Delaware corporation.
Yeah.
So, to that point, that they're there for those reasons. They're there because the Delaware court is known to be a business-friendly, corporate-friendly court, and that's right.
Yeah.
So when it comes, what ultimately drives a lot of times that determination of situs and a corporation's ability to decide where case is going to be heard.
So before we get into CITES, let's talk a little bit about Delaware, because you raise a really interesting point. Delaware is becoming very much of a wild card.
It has changed. I know it has changed recently.
Now
Everybody's going to Texas now.
Yeah. Now you are spot on that many companies are incorporated under Delaware law, and a lot of the venue selection and legal selection clauses are based in Delaware. But there have been trends in Delaware courts where some judges are getting the reputation, justifiably or unjustifiably, as being activist judges. You can look at some of the decisions that have come out of there where some of the judges have really kind of gone into an unforeseen area of whether or not they're going to enforce certain, stock restrictions or compensation agreements that have already been fully agreed to by the company. So Delaware is a little bit of a wild card.
Yeah.
But getting back to the heart of your question, what is a controlling jurisdiction really depends upon a number of factors. The number one controlling factor is usually the location of the company, either its headquarters or where it operates a significant part of its business operation. So if you have a business in Huntsville, but you also have a significant presence in Tysons, Virginia, then it's reasonable to will be honored. The courts will honor a Virginia selection. It has to have some kind of a logical nexus with the case. So you can't just say, all disputes are going to be resolved in Wyoming, because the judge is going to be like, well, what does Wyoming have to do with anything? And although there's usually a lot of deference that goes to that, it's not totally uncontrolled. But the geographic location of the company and the location of the business operations at issue in the case are going to play a role, and then ultimately, I think the management will play a role. I think that companies don't reflect on an appreciation of the fact that they control this. This is a completely controllable issue. If you make a decision that you want to go to arbitration and have it managed by the American Arbitration Association, go for it. I'm not here to badmouth the American Arbitration Association. They are good people that do fine work, but there just seems to be some kind of an implied assumption that people just say, we're just going to throw the AAA clause in there and we'll just deal with it later. You don't have to do that. And therefore, it's something that really is going to have a very significant impact over how your company is going to have to deal with these cases down the road.
And that kind of takes us to a next topic we want to touch on. Is we talk a lot about, in the HR, documents.
Mm-hmm.
We've got employment agreements and employee handbooks.
Sure.
These things, like CITES, and where these things should be,
right,
are these things that should be consciously thought out and made a part of the language in these documents, so it's very clear that the company has a control of what they're going to do.
Yeah.
And then a kind of a follow up to that, Seth, is specifically around arbitration clauses.
Mm-hmm.
What thoughts should companies be having about when they include these, when they don't include these, and into what documents?
Yeah, it's a good point, because we can talk about it in the abstract, but then the HR professional will say, okay, so then where are my target documents? What are the source documents? Well, first and foremost is for example, the employment agreement. The employment agreement should have a venue selection clause on how to be able to resolve disputes. And keep in mind that although certain EEO-related complaints first administratively have to be filed with, for example, the EEOC, the Equal Employment Opportunity Commission, or their local Federal Employment Protection Agency, or what is known as a FEPA. That's just an initial administrative phase. They are going to ultimately, after exhausting those administrative remedies, they're just going to bubble up to litigation anyway, potentially. So you're going to, HR professionals will be looking to the employment agreements. They should be looking to their handbooks. They should also be looking at their consulting agreements. If somebody's a 1099, then you still want to be able to control that. If the company is here, but the 1099 is somebody who's doing work out of a place in Boston, you don't have to go to Boston. You can just play on your home turf. Yeah. And as you said, you want to keep home court advantage. So, but those are the documents that I would take a look at, and you can review them at any time. There could be a point in time as a natural transitional progression. You could look at something middle of the year. You could look at it and make a determination and say, you know what, I think that when we get back from 4th of July break, we're going to come in and we're just going to go through an audit or go through some of these things. As you would want to do in some of your other elements of your agreements, based upon changing circumstances, not only within the company, but also changing circumstances within other court decisions. So for example, and I won't go off field on this, but decisions change relative to non-competition, non-solicit, and non-compete agreements. So you're going to want to review your agreements periodically anyway. This should be part of what you look at when you lift up the hood.
So, obviously we're addressing arbitration and litigation. There is another alternative path, mediation.
Yes.
That some people talk about. So where can and should that be a part of the decision matrix?
It's an interesting question. So sometimes in some contracts, companies have a mediation requirement that basically says, look, no one's telling you that you can't go to court, regardless of whether it's in state or federal court or whether it's in an arbitration panel. But we require mediation for, let's say, for a period of 30 days before you do so. What is mediation? Mediation is a non-binding, voluntary negotiation process where the parties converse for a certain defined period of time or a not to exceed limit for pre-litigation to determine whether or not they are able to work out their differences. So from that standpoint, there's certainly nothing wrong with that. Sometimes there's a little bit of a confusion or a blurring of the lines between mediation and arbitration. Mediation is a voluntary practice that results in a non-binding conclusion. Arbitration is a voluntarily agreed process that results in very much of a mandatory conclusion, which gets stuffed down your throat and which is 99 times out of 100 unappealable. It's binding, it's unappealable.
Yeah.
You get what you get and you don't get upset. So mediation can be a good thing. The one thing I would say is that I would have a not to exceed time cap, which is pretty short. So in other words, it's a great idea for people to talk. A lot of times, and Declan actually has said this many times, and I think it's one of the many reasons why he provides great advice. One of the best ways to try to keep the temperature down in the HR room is to always keep the conversation going. And when you're able to have a conversation, which is really what a mediation is, there is a way to keep the temperature down. And that's one of the things that he says that's really a good point. The problem comes in when it just goes on and on and on. So I've seen contracts that say, but you first have to go through a process of 45 days of mediation. Well, that's a long time. I mean, why can't you talk in 4 or 5 days? Yeah. So I would say it could be a good idea, but you don't want to let it drag out because otherwise all it is it's just going to be an artificial barrier, which is just going to end up eating up too much time. And
in a mediation process, if there is, again, it's not binding.
Right.
Literally, terms can be agreed to, and then they are taken to a courtroom, to a judge, to then finalize and approve kind of what has been mediated. How is that kind of what's the end game of that mediation process?
So that's a great distinction. So there are two different examples of mediation. There's pre-litigation mediation, and then there's post-litigation or post-filing an opening of the complaint mediation. The first is when parties talk privately to try to work out some kind of a contractual agreement. If they say, okay, we'll do a little bit of horse trading, we'll do a little bit of give and take, you can just enter into a private agreement, resolve the differences, and then you're good to go, at least in theory. Mediation is an available option as a common matter, of course, during litigation. So what courts are usually doing, and it's even in an initial scheduling order, part of it, among other things, will say, look, you need to tell me within a date certain, the clerk's office or the judge says, whether or not you want to elect to have mediation as a part of this process. And if you are in that situation and you enter into mediation and it works, then great. Then you would enter into a final agreed order, and then it would have to be approved and entered by a judge.
Yeah.
And that can be helpful. There are some times in court where a mediation can be a really good idea because it helps the parties sit down and have a conversation. Hopefully the court-appointed mediator is good at what they do. I've had some mediators that are not effective and some mediators that are very effective. There are other cases where if the lawyers are able to have a reasonable professional relationship, I would argue that you don't necessarily need a mediator, because if the lawyers have a respectful professional relationship and they're just not playing a bunch of acrimonious, games, they should be able to sit down and have a conversation. Yeah. In theory, that's really wonderful. Does it happen in real life? No, because you have, just like you have all different kinds of cases, you have all different kinds of lawyers on the other side. So it depends, but it just reflects how you're going to have a lot of tools in your toolbox to be able to hopefully try to wind this down. The last thing I'll say before we go to the next question is, I find that sometimes mediation is a good match with the case still going at a full clip, because sometimes you need to have the leverage of a case moving with speed in order for the other side to have a little bit more, find a little bit more.
Deadlines help decisions always get made, right?
Yeah, because sometimes people would just look at that as kind of like a case vacation. That's not, that doesn't apply any kind of pressure.
Yeah.
Yeah.
So in our remaining time here, there is one specific kind of question which relates to choosing arbitration versus litigation, that I guess has created some specific laws around, and that is, specifically, I guess there's been times where employees, with regards to discrimination cases,
Yes.
and employers not wanting those to be in the public courthouse and in public light, and the ability of an employer to force an employee in a sexual discrimination, say, case to only do it through arbitration so they can protect their dirty laundry.
Yeah.
I believe there's some rulings and laws that have come out to eliminate that. So why don't we just talk about that specifically as we end up?
It's a great point. So in 2021, Congress passed a law. It's called Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which says in those cases, the employer cannot force arbitration of sexual harassment claims. So that is an important exception, and that is not going to be brought into the arbitration venue because Congress has said we're not going to allow that to happen. There's also been other cases that have said that if there is going to be an arbitration directive, that related claims also have to get shifted over into arbitration so that you don't end up with case splitting. So there are some rulings, but that statute I think is predominantly what you're referring to, and that's something to definitely keep in mind. And the idea on that is that bad actors don't deserve to get the benefit of acting in the dark. These are things that need to come to the light of day, and companies shouldn't be rewarded for having an environment that involves those kinds of allegations. So that's certainly one of the elements of federal law that comes into play.
All right.
Yeah.
Well, I've learned a lot about things I hope I don't have to put into practice or use anytime soon, but I think there was a lot of very helpful information here and useful information. And again, planning is all part of it. Location matters. Some of the key takeaways, I think, from today's conversation. Before we do wrap up, we do have a couple minutes. I'm going to bring up, just so we can touch on it briefly.
Yes.
We always like to cover breaking news here on the Roundup.
Sure.
Last Thursday, since the new administration came in, we have talked a lot about executive orders. We have talked ad nauseum about executive orders regarding DEI-related issues and new changes related to DEI.
Yes.
The administration last Thursday came out with another executive order with regards to DEI requirements for immediate action for government contractors.
Yes.
So this is more kind of a public service announcement in case anybody wasn't aware of this. 10,000-foot view, Seth, what do
Yeah.
our listeners need to know about this EO last week?
So there's an executive order that gives a deadline of, I believe it's the 25th of this month.
30 days, yes.
Yeah, so
that's
there's
why I wanted to bring it up. I didn't want to
Yeah.
wait till next month's podcast and say you have
Yeah,
3 days.
it's exactly right. That's a good point.
So I was like, we can get this out today.
Yeah,
We're
that's a
not
good
back here
point.
for another month.
Yeah, no. So you've got a couple of weeks left. This is an executive order. It's basically a little bit of an administrative headache for companies to flow into their contracts and flow downs in subcontracts that provides about a half a dozen mandatory contractual provisions that in the essence of it says that you are going to enforce non-discriminatory elements of avoiding the world of DEI. And that as a result of that, via executive order, there are these promises that are going in that says that you're going to observe that, you're going to monitor that. If you see something askance, you're going to report that. So you're absolutely right. It's a little bit of an administrative headache, and now you've got about 3 weeks left to plug it in. So there you go.
Yeah, I hate coming on here and being like the bearer of bad news.
Yeah.
But the thing that stood out for me, I mean, specifically, requiring amendments to existing subcontracts, revisions of internal corporate policies, and imposing FCA liability. So basically, this created a lot of work potentially for a lot of people. Again, my apologies if you didn't know about this already. I hope I just didn't ruin anybody's day. Yeah. But we're giving you 30 days and not 5 if we talked about this next month. So that's our public service announcement today on the latest EO on DEI from our breaking news desk. So again, thank you everyone for joining us today. We hope everybody's having a wonderful spring. Hope everybody celebrating has a wonderful holiday weekend as we head into that. With regards to our upcoming schedule, we will be back in May. I got it. Schedule here somewhere and make sure I get the date. So we will be back on our normal third Thursday schedule in May. So that will be May the 21st. So we look forward to seeing everybody then. Again, enjoy spring. Have a great day. And we look forward to talking to you next month. Take care.